the rules to regulate proceedings for contempt of the Supreme Court 1975. These rules have been framed by exercising the power of the Supreme Court in Section 23 of Contempt of Courts Act 1971 and Article 145 of the Constitution of India, and all other powers enabling in this behalf. So, Supreme Court of India, by using Section 23 of Contempt of Courts Act 1971 and Article 145 and all other powers enabling the Supreme Court in this behalf. So, by using all these powers, these rules have been made. Now, scheme of the rules. It contains 3 parts. Part 1, Part 2, Part 3. And it contains 16 rules and 4 forms. Part 1 deals with Rule 2, which is dealing a direct contempt. We can call it as a direct contempt. That means which contempt has been done in the presence or in view or hearing of the court. So, that is called direct contempt. So, how direct contempt can be dealt with? That procedure and that mode of contempt has been dealt by Rule 2. That is Part 1. Next, Part 2. Part 2 deal with the other type of contempt, that is called criminal contempt. So, it may be, we call it as indirect contempt or contempt not directly or not according to Rule 2. So, the entire part deals with the procedure of dealing this contempt. So, these contain several parts, several rules. Rule 3 to Rule 15. This part contains Rule 3 to 15. So, it gives a detailed description of the criminal contempt or the contempt other than Rule 2. Then what is Part 3? Part 3 contains conviction procedure. That means once contemptor found guilty, how conviction has been given, how it has been executed. So, all these procedures given in Part 3. So, these are the 3 parts. Coming to forms. The notice to contemptor. Form 1. Okay. Next, warrant of arrest. As envisaged in Rule 11. That is Form 2. Next, bail and bail bonds. That is original jurisdiction. That is Form 3. Next, Form 4. Form 4, commitment of contempt warrant. That means how to send the contemptor to jail. So, these are the 4 forms. They are the 4 forms. So, this is about the scheme of the rules. Okay. Come to Part 1. What Part 1 says? Direct contempt. So, according to this rule, if any person committed contempt, in view or presence or hearing of the court, the contemptor, so that is rule 2. Then, what can court do? May be punished by the court. Which court? Before which it is committed. So, when contempt, not when, where? Where? Contempt, where? Next. Punishment by whom? Punishment by whom? By the court before which it is committed. Next question, when? Forthwith or on such a date? As may be appointed by the court in that behalf. So, where, when, whom? Here. Over. Next. So, rule 2 contains 2 sub-clauses. Now, we dealt with the rule 1. Next, what is rule 2? Rule 2 enabling the court to detain the contemptor pending the determination of the charge. So, rule 2 enabling the court to detain the contemptor pending the determination of the charge. Detained in such custody as it may specify. Where has to detain? Anywhere. It may specify. Court has to specify. Then and there, it is also enabling the court to grant bail on such terms as the court may direct. May be released on bail. So, enabling custody, enabling detention, enabling bail also. So, that is rule 2. Next, come to Part 2. In Part 2, rule 3, another type of contempt. Here, it describes another type of contempt. This contempt can be initiated. How it can be initiated? Number 1, by sumoto. Number 2, on a petition. Who has to make petition? Number 2 means being. This petition may be made by Attorney General or Solicitor General. Or even other than Attorney General, Solicitor General or sumoto also, this contempt petition may be moved. By whom? Any person. Provided if it is a criminal contempt, it should get the consent in writing of the Attorney General or the Solicitor General. Either Solicitor General or Attorney General has to give written consent to move criminal contempt by any person. If it is civil contempt, no such thing is not necessary. No such thing is necessary according to understanding. So this is rule 3. So rule 2 envisages one type of contempt. Rule 3 envisages another type of contempt. Now, come to what are the prerequisites? What are the prerequisites to move a contempt petition? Already we discussed some prerequisites like a petition by Attorney General or Solicitor General or any person, or in the case of criminal contempt, written consent also is necessary. It is also a prerequisite condition. Written consent of Attorney General or Solicitor General. Okay, then come to 4. For the petition, which details have to be incorporated in the petition? If it is a petition under Rule 3B or Rule 3C, if it is a suo motu, there need not be any such details. If it is Rule 3BC petitions, then the following details should be there. What are those? One is the name, description and place of residence of the petitioner or petitioners and of the persons charged. So, name, description and place of residence of the petitioner or petitioners and of the persons charged. That means you justly simply it is called a cause title. You can call it as a cause title. Next, nature of the contempt alleged. So, nature of the contempt alleged. Such material facts, including the date or dates of commission of the alleged contempt, as may be necessary for the proper determination of the case. So, nature of the contempt, material facts, the date or dates of commission of the alleged contempt, as may be necessary, proper determination of the case. It is common in all petitions. Now come to 3. If a petition has previously been made by him on the same facts, the petitioner shall give the details of the petition previously made and shall also indicate the result thereof. So, details of previous petitions. Details of previous petition. It is also common in all petitions. Next, affidavit. Petition shall be supported by an affidavit. It is also common. Next, documents. List of document or documents in his possession or power. He shall file such document or documents or true copies thereof with the petition. So, affidavit and document. No court fee shall be payable on the petition and on any documents filed in the proceedings. So, this is Rule 4. So, all these are very, we can see all these details in all petitions naturally. So, it contains 4 clauses. Rule 4 contains 4 clauses. Okay. Next, what about Rule 5? We will see in later video regarding Rule 5 to other rules.